Okay, great. It looks like we're ready to go. My name is Laura Ann Fernia. We're delighted to be with you today. I'm going to be the moderator and going to start by setting a little context about eviction and our legal system. But each of our panelists will be giving you lots of information about that in their particular field. But we're going to start with a very short presentation about eviction itself. And also just want to let you know for questions, we'll be doing those all at the end, but you're welcome to put them in the Q&A part during the session, and our panelists will be addressing those at the end of the session. Okay, I'm trying to share here. So hopefully everyone can see. Please let us know if you can't. And I'm going to, this is our intro page. So we are talking about eviction and fixing the eviction system, particularly the legal system today. For some reason it's not moving. I do not know why my computer is not working. There we go. Okay, so there are three types of evictions. The first one that we're going to be talking about today are court-ordered evictions, where the landlord uses the court process to evict a tenant. Informal evictions are actually the most common type of evictions. That's when the tenant leaves upon receiving notice or a threat, despite being entitled to stay. So they're involuntary, which are all evictions. And then illegal evictions are those evictions where utilities are cut off, or there's some kind of lockout or harassment from the landlord or property manager. So today we're going to be talking about court-ordered evictions, which are actually the smallest number of all the evictions. Oops, sorry. Eviction is, as you can imagine, a cause of homelessness. Qualitative studies, for example, when tenants facing eviction were asked about their alternatives, if they were to lose housing, 81% said they were either likely or very likely to become homeless, and that 41% of those saying that homelessness was very likely. And quantitative studies, for example, in New York City, they actually talked to shelter residents and looked at shelter applications, and a very high percentage in terms of eviction were likely to have eviction still after. As after an eviction, they're likely to be homeless, and also the evictions increased the share of days spent in the shelter by approximately 36 days. Some of the negative health outcomes of evictions are really incredible. I think the one that really stands out, I'm not going to read all of these, are the physical ones and the ones specifically to children, because when you traumatize children, as I think we all know, it affects them for their entire lives. And when children are evicted, they are taken out of their community, they're taken out of their homes and their schools, they're taken away from their friends. So some of the many results, especially in health, is academic decline, food insecurity, emotional trauma. They risk being chronically ill in adulthood, and decreased life expectancy. And this is also true there's very many effects for adults as well. Higher mortality, a lot of health effects, even emergency room patients have been interviewed, and so many of them have been evicted. So eviction is just a really, really big problem for many, many reasons. It also affects renters in terms of their credit score and not being able to rent as easily after an eviction. So one of the solutions we've come up with in San Diego is creating a collaborative. And our mission is to reduce avoidable evictions and the resulting homelessness and long-term damage to individuals, families, and children. And we work towards system change that empowers tenants and expands public awareness, reduces human and public suffering, and builds economic and racial justice. These are 5 proven strategies that we use in the collaborative that are evidence-based and best practices around the country. Coordinated outreach and referral, where we try to coordinate our services and our resources for tenants in the county and in the region. Specifically targeted tenant education and empowerment, especially in high lockout rates in neighborhoods and areas and homes and apartments that are specifically at risk of eviction, particularly. Legal services, where we tried to coordinate the legal services that exist so that those that are most needy and the most in need of representation do get that. Accessible rental assistance, I think as we've all been through the pandemic, we've learned a lot more about that and why it's so important to have rental assistance accessible. We started a website specifically for tenants that they can find any of the available rental assistance in their area, as well as workshops to learn about their rights. And finally, strong evidence-driven policy, meaning that we're using information and like the research I just shared with you to drive policy that's more protective of tenants and keeps them in their homes. So this panel of attorneys will address their legal experience of evictions within their specific context and present ways to fix our broken eviction system and keep more people housed. And with that, I want to move on to our very first panelist, which is Gilberto Vera. And I have to stop sharing. So I'm going to read Gil's bio while you answer these questions about his panel, which you can then use. So Gil holds a bachelor's degree from the University of California, Berkeley, and a law degree from Loyola Law School in Los Angeles. A first-generation Mexican-American, Mr. Vera is a South San Diego native who has dedicated his career to public service by helping indigent communities in Los Angeles County and currently in San Diego County. Mr. Vera is a senior attorney of the housing team at the Legal Aid Society of San Diego. Throughout the COVID-19 pandemic, Mr. Vera connected residents to rental assistance, legal representation, and bilingual access to the constantly changing COVID-19 tenant protections that proved invaluable to households in San Diego County. For his tenant-focused work during the pandemic, the California Young Lawyers Association awarded Mr. Vera with the 2021 Jack Berman Award of Achievement. Thank you, Gil. And I believe we're going to wait till the poll's finished and get the results, and then Gil will start.
Thank you so much for the introduction, Lauren.
Sure.
Yeah, I'm just giving people a minute or so. It looks like the poll is ending in about a minute. We'll start sharing my screen as we wait for the poll to end. Okay, I will go ahead and start our presentation. I'm going to be covering kind of the expedited eviction process and barriers to access to justice. I'm going to highlight some barriers to access to justice that my co-presenters will be addressing as part of their presentation. So my presentation will not be covering everything that I'm listing. I'm going to just share the results of the poll for those who want to see. So these are the main barriers to access to justice that we've identified, specifically for low-income households who are particularly vulnerable for homelessness. The expedited timelines of unlawful detainers are very unforgiving, especially to tenants who don't know their rights. The lack of right to counsel, right? On top of a very expedited legal process, we're also expecting tenants to be able to represent themselves. And if the tenant cannot pay their rent, they definitely cannot afford an attorney to represent them in an eviction court. So it kind of compounds the issue that the expedited process creates. Court consolidations as well have made it even more difficult for tenants to access free clinic services if your county is consolidated or unlawful detainers, like it is the case in San Diego County, which I'll cover later. It becomes a massive barrier to access to justice and leads to increase in the amount of defaults, which tenants are automatically losing before they even get a chance to respond to a lawsuit. There's also the uneven risks in eviction court. We're going to cover how there's a disparate outcomes, right? Like the tenant wins, right? They generally, don't get, as favorable results as if the landlord wins, and we'll cover that as well. Tenants not knowing their rights. Like Lauren kind of covered, that education outreach is crucial and empowerment, so tenants don't self-evict before they even have a chance to assess whether their eviction is even lawful or not. There's also a lack of stronger tenant protections at the local level. I know the state has attempted to create some sort of structure with AB 1482, the Tenant Protection Act of 2019, But as we all know, those who do housing, it is a flawed law with a lot of loopholes that essentially local governments are the ones kind of tasked to plug. Also, specifically for immigrant tenants, there's a natural distrust and fear of the legal system, right? Especially if you're someone who doesn't have a legal status in this country. Going to court can be very scary. And even if you do, you might come from a country that where you don't trust the legal system, and so you already have a natural distrust of the legal system. Additionally, there are even additional barriers for elderly and disabled tenants that make it very difficult for them to engage in the eviction process. So here's kind of a flow chart of of the natural progression of an eviction, right? Every eviction always begins with a notice, generally, right? If we're talking about a formal eviction for the most part. There are certain exceptions when notices aren't given, but generally it begins at the notice stage. Once that notice expires, the landlord is allowed to then file the eviction lawsuit. Once the tenant is served, they have 5 court days to respond, a very short time period. And it used to be 5 calendar days, just a recent change in 2020, which essentially buys tenants some additional days. But even if we're only counting court days, there's a very quick process if you're personally served. And if you don't file an answer within the amount of days that you're required if you're personally served, then on day 6, the landlord can request a default, which then sends the tenant on this even more expedited track of getting locked out of their home and made homeless. Because at that point, even if the eviction was wrongful and unlawful to begin with, if the tenant can't timely respond to the lawsuit, they'll lose automatically. And in our experience, at least in San Diego County, it can be very difficult to set aside those defaults and convince a judge that the reason your client couldn't respond is because they didn't know their rights. They didn't have to respond in 5 days. That's generally not enough. It's not going to get you anywhere. And I don't speak English is not going to get you anywhere. At least that's what we've seen in our courts. It's not going to be an excusable reason why you didn't file within those 5 court days if you were personally served. And the reason that's so crucial is that if the tenant doesn't file within 5 days, on day 6, the landlord can request an eviction, a judgment be entered. Typically in our county, sheriffs execute lockouts within 3 to 4 weeks of a judgment being entered. So that means that a tenant who is receiving an eviction and doesn't file doesn't file a response can potentially be locked out, 4 to 5 weeks after they're served with the lawsuit, right? It's a little over a month. And it can be devastating to tenants and a lot, especially those that are defaulted. A lot of them do end up becoming homeless because there's generally not much we could do at that stage if we can't find a good reason to set aside the default. And I just kind of want to compare and highlight how much quicker evictions are compared to general regular civil litigation, right? It's evictions are one of the fastest moving lawsuits through our court system, and it's by design. It is a statutory process created by our state legislature because landlords need a quick way to remove tenants from their property, right? In typical civil litigation, generally defendants have 30 days to file an answer, 5 court days for unlawful detainer. Typically, right, you can't, in civil litigation, can't request a default, assuming they're personally served until 30 days after service. And there's some other things you have to do before you can even request a default in general civil litigation, depending on the case. Unlawful detainer, 5 court days. Also, the discovery cutoff is so quick, which also makes it difficult for us attorneys as advocates that we are not able to connect with that tenant early enough in the legal process, which generally means before they're served with a lawsuit. It can be very difficult for us to get sub into a case before the discovery cutoff. And in general civil litigation, 30. And that's also separate from the fact that in general civil litigation, it can vary from county to county, but generally, your trial might be set 9 to 12 months after the lawsuit is filed. In unlawful detainers, by law, the trial must be set within 3 weeks, 21 days from when a party requests the trial be set. And it's almost always the landlord, right? Because they are the ones who have a vested interest in speeding along the process. And so generally after the tenant files an answer and serves it on the landlord will immediately request the trial be set. And in our county, and at least we've seen landlord attorneys, their common practice is on the day after the time for the answer to file expires, they file a request for a default, and then they file a request for trial be set. That way, either way, before they're even served with the answer, they're either the case is going to be defaulted or the trial is going to be set. And so generally, because of that, trial can be set as early as a month after the lawsuit is filed, which is a very, for those of you who do other types of litigation, it's kind of an insane timeline. And that kind of segues, aside from how crazy that timeline is, if you're able to still file an answer in a timely manner, there's still an uneven balance of risk. And these are kind of the landlord outcomes, right? If you as a landlord, if you lose, the tenant gets to stay. And then the landlord and the tenant pays you whatever rent is currently unpaid. Because generally, depending on the type of eviction, it could be for non-payment, it could end up being for another reason. But typically, once a notice expires, the landlord is no longer accepting rent. So by the time you get to trial, even if you as a tenant you win, you probably have about a couple of months of rent that have accrued. And so the tenant is still generally liable to pay that amount of rent that's owed. Some exceptions, when there's some habitability defense, the court can reduce the amount of damages. If the landlord loses their title, they could be liable for the tenant's attorney's fees. However, landlords typically limit attorney's fees cap between $1,000 and $1,500, and that's because that's generally how much it costs them to file an eviction. And you're only entitled to attorney's fees if you hire an attorney, which most tenants do not. And so even with the attorney's fees clause, even though it's something that's mutual, it generally has uneven outcomes because they generally benefits the landlord more than it benefits the tenant. And also because of how expedited the process is, even if the landlord makes a mistake, they might be able to just reserve a notice, correct that issue, and start right all over again. And so we're now essentially round 2 of this eviction. And evictions can be extremely stressful on families. It sucks up time of the tenants have to take off work that they already can't afford to pay their rent, and now they have to even forego working to have to deal with this eviction. If the landlord wins, right, they get judgment for possession, a judgment for the owed rent, and generally can, like I mentioned, lock out tenants 3 to 4 weeks after that judgment is entered. And they get their attorney's fees and costs, which even if it is capped, like I mentioned, they generally cap it at what their costs generally are. And that's because if they lose, they don't want to be liable for their tenant's attorney's fees up to a certain amount. And let's go over now what happens when the tenant, what are the outcomes for the tenant, right? If you lose, you'll be locked out of your home in 3 to 4 weeks. You'll have a money judgment against you, and likely with attorney's fees and costs. And more devastating, you'll have an eviction on your record, which we already know statewide, we have a housing crisis. But specifically in San Diego County, like I know other cities in California, the rental market is hyper competitive. And if you have an eviction on your record, it's going to be almost impossible for you to secure future housing because the landlord has 10 applicants. And if one of them has an eviction, they're not even going to consider him or her. Also, if the tenant can't pay the money judgment, which a lot of tenants cannot, the landlords typically send that to collection, which further damages tenants' credit. So not only do you not qualify because you might have an eviction on your record, but also it affects your credit score, which makes it even more difficult for you to be able to rent. Also, if the tenant has subsidized housing, like Section 8, they lose their housing subsidy. And so what you usually find with Section 8 voucher tenants is they're really risk adverse. And as their attorney, we're generally also really risk adverse because they have a lot to lose. That voucher is really valuable. And for many of those in the program, it's the only way they're able to secure housing. Now let's go over what happens if the tenant wins. They get to stay in their home, which is great. But they also have to pay any rent that's been accrued through trial, like I mentioned. Also, like I mentioned, the attorney's fees, they're entitled to if they hired an attorney, and generally they're capped. But what the court will not do is they will not award tenant any money damages against their landlord. It's just something that's not available within the unlawful detainer process. And it's by design. They really the reason they created this quick process is to get the tenants out. It is not meant to be a court that provides justice for tenants harmed by their landlord for the most part, which is why tenants are not allowed to do counterclaims in unlawful detainers. Now I wanted to kind of highlight the issue of court consolidation. This is San Diego County. We are the second most populous county in California, the fifth in the United States. We're a massive county, as you can see on that map. And in this entire county, only one court hears unlawful detainers for the entire county. And that is something that has happened over decades as court consolidations due to court budget cuts generally affect unlawful detainer lawsuits. They're seen as the bottom barrel types of cases that our court system deals with, and they are funded that way. San Diego County has 5 superior courts. 2 are located in downtown San Diego that deals with civil matters. 1 in North County, 1 in South County, 1 in East County. At some point, there were unlawful detainer courts in each of these geographical areas. The last one was consolidated in North County in 2017 into downtown. And so what that creates is that coming to downtown San Diego can be really costly, especially if you're out in the outskirts where public transportation doesn't reach. Also, going to downtown means you have to pay parking, which is generally expensive. And so if you're a tenant, again, you already can't pay your rent, you already don't have money, and you have to incur this additional cost. Also, our other superior courts will not accept any in-person filing of unlawful detainers, any documents related to unlawful detainers in their court. So you as a tenant, even if and that's because before this, legal aid would staff unlawful detainer clinics at each of these courthouses. We no longer do, because even when we were doing that, that tenant, after we prepare their paperwork, would have to drive to downtown to actually file it in person. And that's, again, part of what the court has done to reduce cost is e-filing. But it's really, e-filing is really as beneficial as it is for attorneys to be able to quickly get things filed. It is a massive detriment to improper tenants. They don't know how to e-file. They don't know how to interact with the platform. And if they do, they might not realize that they qualify for a fee waiver and will pay $225 to file an answer when they could have gotten that response filed for free and those fees waived. And the only way they would really know that is if they came to one of the unlawful detainer clinics. And so that's one of the reasons why the court consolidation, especially in San Diego County, has been particularly harmful to tenants, and is a massive barrier to access to justice, right? And we haven't even started talking about how this affects, particularly the elderly and disabled, who, as we know, are the most at risk of becoming homeless. And so now before I move on, I wanted to kind of go over the poll to get an idea of how many courts your county handles unlawful detainer. I think the majority of you don't know, but the second highest answer was 1. And I used to practice in Los Angeles, which does have more superior courts that handle unlawful detainers. But I know even then in Los Angeles, there's some consolidation of those unlawful detainer courts, especially into the central courthouse of Stanley Mosque. And the second question, how long does a residential eviction take from the filing of the lawsuit to a trial date? Seems like most of you kind of know it takes about 30 days. And most people don't really know that and might think it takes even longer. But yeah, 30 days on average is how much it takes for an unlawful detainer to get to the trial stage, assuming the tenant actually filed an answer. Thank you very, very much for everyone for your time.
Thanks, Gil. Appreciate all that information. We will answer the question about sharing slides afterwards. We have some panelists that need to update some of their slides, so we probably will be able to do that, but probably not immediately. So hopefully you can just keep in touch, and we'll do it through HOVA somehow or another. We are going to move on to Brittany. And Brittany's questions, I think, are coming. There we go. So I'm going to tell you about Brittany while you're answering this question, or two questions. Brittany works as a housing advocate for Disability Rights California Housing Stability Project. Last year, she coordinated the Fire Safety Project, which focused on preparing for displacement and planning for wildfire evacuations. She was a spring 2021 fellow for the Shriver Racial Justice Institute program. Disability Rights Center's organization is statewide and serves the disability community to address pre-eviction housing issues that often intersect with disability discrimination. Brittany takes a holistic approach to client work and has seen many clients face increases in disability discrimination, harassment, and other intersectional obstacles. We will give you a couple more minutes to answer the poll, and then Brittany is going to take over.
Sorry about that. My screen's switched over. And let me see, let me move this here. Thank you for that intro, Laura. Let me go ahead and pull this up. Does everything look good?
It looks great.
Lovely. Okay.
I think we might be finished on the poll. Let's see.
Terrific, terrific. Okay.
And you can see the results, Brittany.
Yes, I can. Cool. So it seems like for the number one question, do you know what a reasonable accommodation is? It seems like some people are familiar, or many people are familiar with it. And then that's good to know. And for the second question, may a housing provider require a tenant to use a specific form? Many of you said true, but actually it's false. You don't actually need a form to request a reasonable accommodation. So that is a great intro to go ahead and segue into my presentation. So my name is Brittany. I go by she, her. Let me move this really quick. Sorry. There you go. I go by she, her. I'm an advocate at Disability Rights California. I also identify as a person with having a disability. So I know I have a short time with everyone today to kind of give a snapshot of some of the barriers to justice in the eviction system that people with disabilities experience. So my outline for my presentation today will go through a quick snapshot journey of statistics, gaps, obstacles, and some solutions.
Brittany, you know your camera is off. I don't know if you know that.
Oh, yes, I do. I don't really
Okay.
want to see my face while I present.
Okay, that's fine.
Okay, so sweet. Let's go ahead and break into the statistics to kind of give us some context. There are more than 4 million Californians with disabilities. Californians over the age of 65 are more likely to have a disability compared to other age groups. The elderly are likely to experience technological difficulties and could be literate, which has made accessing resources extremely exhausting and frustrating. I know that Gil made comments about that because we did really see the elderly group was sort of left behind during this pandemic, and the switch to remote work for courts, legal services, and service providers, the restricted to times and whatnot, made it really difficult for this group to access any sort of assistance. Also, the next statistic would be lower income households are more likely to include members with disabilities than higher income households. So an additional layer to this, people with disabilities that might include severe intellectual or developmental disabilities often rely on Social Security income as their only source of income. And then another kind of employment element to this is that people with disabilities face challenges in finding work and in keeping work. And then finally, in 2016, the average HUD fair market rent for a studio apartment across California was $1,040, exceeding the total monthly payment of an individual receiving SSI, which was $889. And so I just wanted everyone to see here that, government benefits aren't enough for a person with a disability to live on, or any person to live on, really. It could take one bad accident or one bill for a person's housing security to crumble. Okay, so let's go ahead and break. So let's go ahead and break into some of the meatier parts of my presentation. So gaps, I would say, so first off, generally, there's just a lack of knowledge about disability rights and disability justice. Housing providers and courts, they don't understand the dynamics of how the legal world creates more strain and additional steps for people with disabilities. And sometimes these housing providers and courts don't even know what a reasonable accommodation is, or even what the process entails. And, you know, the reasonable accommodation process, it requires more than just a form. It also requires creativity, empathy, and being helpful. If there's anything that I've learned in serving this community and as a person with a disability, it requires more than just a form. So the next bullet point here is, you know, the disability experience has largely been told from a perspective by those who are usually able-bodied or have knowledge of how to access the legal system. And then the legal system, of course, already is difficult to access. There's also difficulty in accessing housing and disability sectors, such as my organization. I think a lot of nonprofits, we have a lot of these different sectors, and there's a lot of bureaucracy there. It's really difficult for a person with a disability to be trying to access assistance for the eviction process while trying to access assistance for emergency shelter. And at the same time, maybe trying to gain some sort of legal access to advice or representation. So there are a lot of different sort of barriers and obstacles that they have to overcome at once when someone's experiencing an eviction. And then a gap, and this will probably come up throughout my presentation, is trying to access the lack of accessible housing. So the ability to access safe and emergency housing and shelter is really difficult for people with disabilities. And even in some of these supportive or assisted types of living, sometimes the rules within these shelters or assisted livings are very stringent and they're not communicated well. For example, I had a client who was living in HIV supportive housing, and one of the effects of HIV is memory loss, and Alzheimer's, and some loss of motor skills. And so he would frequently forget the curfew rules. He would get notices, and eventually he ended up getting locked out of his unit. So it's just to kind of illustrate how, you know, sometimes there are shelters and supportive housings for people with particular disabilities, but ironically, they're not actually really supportive. So some of the obstacles, my first two bullet points are just kind of, you know, two sentiments that I think resonate throughout my presentation. So housing and eviction policies and practices and procedures just adversely impact the availability of housing to people with disabilities. And landlords and courts generally do not propose reasonable accommodations for tenants. The burden is really put on the person with a disability to affirmatively ask for these. And in the next two slides, I'll be kind of separating these into two sections. So I'll have our pre-eviction obstacles and then our eviction obstacles. I think it's really important to highlight the pre-eviction obstacles as like a period, because it's really important for understanding the day-to-day challenges the disability community experiences. You know, also kind of just like echoing Gil again, the public transportation, a lot of our clients use public transportation. During the pandemic, many of our clients were scared to even use a bus because many of them were immunocompromised. And then the eviction period. So once that core legal process has begun, we'll see that there are few mechanisms to ensure that people with disabilities can defend their right to remain housed or even defend themselves against an eviction. Okay, so some obstacles within the pre-eviction setting. So the first bullet point, I have a lot of clients where they ask for reasonable accommodations, and those can trigger eviction notices from their landlords. We see a lot of our clients, you know, they're late on payments because a lot of them are dependent on SSI or SSDI, have these small fixed incomes. some of our clients get eviction notices because they aren't able to maintain proper housekeeping because of maybe mobility or mental health disabilities. And kind of to build upon this one, mobility issues, we've had clients where their units are so tiny that it's really hard for them to maybe move around with their electric wheelchairs. Door frames could be too narrow, countertops could be too high. Sometimes there aren't enough grab bars available for them to hold themselves up to do some of these daily tasks. In regards to mental health disabilities, we have clients who have hoarding disorders, which are coupled with maybe mental disabilities such as depression or anxiety or ADHD. And these groups, it's not that they don't want to cure some of these violations. It's just that their disabilities, it causes for them to have to get third parties to help them, maybe have their IHSS care worker assist them, or even a family member. This kind of segues to my fourth bullet point, is more time to cure these violations. So if you are asking for a family member or a third party to help you kind of cure these violations, it takes more time. And so even not restricted to the mobility or mental health disabilities, some of our clients, they need time to request for an ASL interpreter or for someone to have them read their documents to them. During the pandemic, I had a client who could not access any resources because everything was closed, and he was blind. And in order for him to actually read the documents that were coming in for his summons and complaint and the notice, he had to wait for his neighbor to come home at the end of the day for them to be able to assist him in reading those documents to him. And so, housing sometimes isn't accessible, permanent, safe, affordable, or supportive in the first place. These are always big obstacles. We have clients who might have accessible and permanent housing, but sometimes it's unsafe and unsupportive. And then sometimes we have people that live in safe housing, but it's completely inaccessible to them. And then, Laura, she talked about informal and constructive evictions. So the way I've seen this play out in the disability perspective is that, we have landlords that will say, well, if you don't like it here, if this isn't accessible enough for you, then you should just move, which has caused a lot of my clients to self-evict. And then constructive evictions, I've seen a tenant ask or has conveyed that she has had respiratory disabilities. And in a way to constructively evict her, the landlord actually shut off the air conditioning, which then causes the unit to heat up and get really hot. And another sort of layer here, I've also seen this kind of domestic violence perspective where I've had tenants who have conveyed to their landlords that they have experienced DV trauma or experiences, and sometimes landlords have taken this more aggressive behavior with knowledge of the tenants' previous DV experiences and preyed on them to also try to constructively evict tenants. So yeah, just to kind of give a purview of what kind of day-to-day conversations or obstacles some of our people with disabilities have to go through in the pre-eviction setting. Okay, and so now we have the eviction setting. I'm going to try to go through this a bit quicker because I have a lot more information to go through. But reasonable accommodations are available, but they are specific to court access and not necessarily to aid a person with a disability in the eviction process. There aren't any safeguards. A lot of these tenants appear pro se, or they're representing themselves, and they have these short deadlines to respond. There really isn't any judicial or court inquiry into whether a reasonable accommodation could allow a tenant to remain in his or her housing. The duty really is duty and burden and responsibility lies with the tenant. And in some instances, tenants really don't even know that they have a right to request a reasonable accommodation. And Some other sort of obstacles we see at play are like nuisance violations. Eviction processes, they fail to account for the role that disability can play in the lives of people with disabilities. The loss of housing, can cause stress and anxiety and impact impulsive behaviors and thoughts. And sometimes nuisance really ends up just becoming whatever the person with a disability does, becomes a violation. People with non-visible disabilities, we don't see that they have the opportunity to be heard in a meaningful manner in the eviction context. People with mental or developmental disabilities, they have limited capacity to understand and process the eviction, to reason, to communicate, or even to control their impulses. So while they're trying to understand, what's going on, they're also trying to manage their own disabilities. Sometimes we even see that these aggressive or negative communications with court workers, judges, and lawyers can trigger disabilities or even trauma. Courts are very quick to process evictions without any inquiry into disability status or even thought to what will happen to the tenants once they are evicted. Just to kind of give you a couple of examples, I've had a client who requested to have an emotional service animal in court because of the stressful environment. The court denied her reasonable accommodation request, which then resulted in the case defaulting, and then she had to do a motion to set aside. And it sounds very fluid when I say it, but as a housing advocate and as other housing attorneys know, like, you need to have some sort of legal representation or legal assistance to do these processes. And I think this really just illustrates the extra steps that people with disabilities have to undergo. And then also to kind of emphasize kind of the ignorance in the court system, 2 weeks ago, I had a client call because they lost their eviction case. The judge during the hearing asked if my client was on SSDI. He said yes. And then the judge asked if he had a disability. He said yes. And then the judge asked if it was a mental disability. And then it made my client feel like he was stereotyped the remainder of the hearing. So I think we just really need to overall understand that, when the courts and the housing providers have to understand that this being ignorant to disability rights or disability justice and the reasonable accommodation process could lead to a cycle of homelessness. It can prolong trauma. It makes a lot of our clients lose hope in us or in any of our legal systems, or even worse, the eviction could cause them to get institutionalized, which really defeats the entire purpose of the ADA. So at my last couple of slides, I'll kind of breeze through these. So some pre-eviction solutions. I think any correspondence between landlords, tenants, and the courts should also be in plain language. Informal meetings before receiving an eviction notice is a really important one. Just an example here, if a child with autism yells or stomps loud in the unit, a landlord shouldn't just be able to serve them with an immediate eviction notice. That parent should have the avenue of having an informal meeting with the landlord to figure out ways maybe to assert a reasonable accommodation request. Placing the responsibility on the landlord to engage in the interactive process with the tenant. Increasing access to affordable and safe housing is also another big solution that I'll just repeat throughout my presentation. So some solutions under the eviction section. Having a longer period to answer the summons and complaint. A 5-day turnaround is just not enough. Accessible virtual appearance options for telephone and video, education for judges, courts, and mediators. We should have judges and mediators maybe have the ability to issue spot when a person may need a reasonable accommodation for their disability. And then, of course, shifting that burden to the court, eliminating these form requirements, maybe even filing and short deadline barriers. Judges should be able to provide a reason for denying a reasonable accommodation request. And then also it would be great to have statewide bias committees integrated within all these California courts, including court stakeholders of diverse membership, to review these rules and policies to make these processes more accessible for varied socioeconomic backgrounds and ability level. I think it's just really important to have a person with a disability with an intersectional lens at the table, kind of providing their feedback on these rules, policies, and regulations. And then finally, I think a really great solution would be having some eviction diversion programs, which is a holistic combination of services to divert that landlord to dispute away from a court judgment. And there's like a nice little illustration here on the right to kind of show the different dimensions of that. And finally, of course, data. We all love data, especially in a lot of different worlds. Data tracking, it would be nice to have more data tracking that focuses on maybe tracking the number of reasonable accommodation requests in court, tracking demographics of move-outs, eviction notices, and unlawful detainers in subsidized and supportive housing. So that is the end. And I know I went a little bit over, but I'm just overly passionate about this. And just thank you everyone for listening to me today and sharing this space with everyone.
Thank you so much, Brittany. It was great. We appreciate all that information, and we are all learning from each other. So it's wonderful. We're going to have another poll before Leah Simon Weisberg starts speaking. I'm going to tell you a little bit about her while you get to see the poll. Leah Simon Weisberg is an expert and statewide leader on rent control, landlord-tenant law, and anti-displacement policy. She's presently the legal director for ACE Institute, a statewide institute. She represented Moms for Housing in court, fighting for their right to live in an empty corporate-owned home on the grounds that housing is a human right. Leah drafted the first new rent control ordinance passed in almost 30 years for the city of Richmond, sparking a tenant protection renaissance. Thank you so much for being here with us, Leah, and we're going to see what happens in this poll before you start talking, but you are welcome to take over now.
Great. All right. So funny how we all doing this a million times now, and yet we're still trying to remember. I don't have access to share my screen. Can someone give me access? I'm now able to. Great. All right. So looking at this poll, the poll results, we've got the largest chunk, or 42% of the folks don't know whether they live in jurisdictions with any of those protections. And we've got kind of the other half do have rent control and just cause. And 15% are considering it, which is really exciting. All right, now I think I'm sharing my screen. I'm going to share the slideshow. So I can't see my picture, but can someone just confirm for me that you can hear me fine and see the slideshow?
I can't see yours yet either, so I think you have to.
All right.
There we go. I think.
Okay, now you can see the.
See you. So now try sharing. You should be able to see it.
Okay, you can see me. All right, are we all good to go, Laura? Okay,
yeah,
great.
it's perfect. You got it.
Great. Okay, so Martina and I are actually kind of sharing our slideshow, but she'll be jumping in a little bit later because we're talking about some of the, I think so far we've been hearing about kind of all of the issues, and I think that both Gil and Brittany talked about some solutions, but we're going to be diving in a little bit more about what we do have in California that works and some models that we hope we're kind of more solution focused with some things about things we want to change. So I'll first off, I think when we're talking about tenant protections, and I think at least what I would be putting forward, and I think all of my esteemed panelists would agree that we know from across the country that there are certain things that really lead to safe housing, prevent homelessness, and prevent that really sad list that Laura, you had shared with us earlier about kind of all the bad, kind of not only the outcome of eviction, but like everything that flows in a negative way from it. So what are great programs to have, things that we need? So proactive code enforcement, meaning that we're not waiting for complaint based, but we're taking care of and creating healthy and safe housing. Anti-harassment ordinances to make sure that tenants are in, kind of a Zen housing, just the way we don't want to have, be in the workplace and feel harassed. People don't want that in their homes. Fair housing laws, obviously, we want to be protected from discrimination based on who we are. Just cause for eviction, which I'll go into a little bit more deeply, but big picture protects us from arbitrary evictions. And then rent control or rent stabilization, which is what the most we can have in California, creating situations where people can afford their housing and are ideally we'd only be spending 30% of our income, even though I don't think anyone is able to do that anymore in California. And then the other piece, and Martina will be jumping in on this, is that you need enforcement of these programs and specifically legal services to protect rent control and just cause protections. So, a lot of folks, talk about California being this like fabulous place where we have all of these things. Well, unfortunately, it really depends on where you live, what protections you have and the extent of your protections. So this is a chart. It's not every city. It really actually are the cities where ACE, where I work, where we have active chapters. And you can see that it's pretty amazing that San Diego, which is, I think we were saying, what, the 4th largest county in the state, huge city, has very few of those protections. And then we've got places like Oakland and San Francisco and Los Angeles that really have a whole other fabulous grouping of protections. And when you look at how people survived during the foreclosure crisis and who popped back fastest, and then again during this crisis, where are the largest deaths been? Where are the highest rates of COVID and COVID deaths have been in the same places that have the kind of weaker tenant protection. So it kind of just, all of these things kind of layer on top of each other. But there are many programs. It's not just the few that we were talking about, but there's lots of pieces. And what's exciting is that we have lots of places in just our state that people can look to. We don't even have to go outside of California to find all these wonderful ideas and see how they're working. So, so you think with all of these, we have not only state protections, local protections, but in 2019, we passed some state protections. And while it's better than nothing, it's not enough. And so at least the thrust of my kind of ideas for folks to think about, food for thought, is that we still have a lot of work to do that needs to be done at the local level. And I hope to encourage you to, at the local community, keep on fighting and striving for these protections. So first off, the rent's too damn high still. And this is actually how many hours you had to work. And this is before the pandemic. And these numbers are a little bit, in terms of what the minimum wage is, a little bit lower. But unfortunately, the rents are so much higher now than they were before the pandemic in most places, as far as I can tell, everywhere in California, that nobody can work 126 hours, but that's what you need to live in Contra Costa, 177 hours. And there are plenty of people who are still only making minimum wage, although it's a bit higher in California than in somewhere in the Midwest. There's still plenty of people only getting paid that. So and we don't have rent control or even rent stabilization at the state level. I just zoomed through all of them. So what do we have in terms of the regulation of how much your rent can be increased? So rent control kind of doesn't really describe anything in particular, except saying that the government has a conversation about and a role in how much the rent can be. What we technically have is rent stabilization, which means the landlord gets to choose the original rent at the beginning of a tenancy, and then the law then regulates how much it can go up. right? So if the cities that have rent stabilization or rent control, it's all tied to the CPI. So let's say you rent your apartment at, $1,000 a month or 2,000, which is probably more likely these days. The landlord decides that original amount, and then your local community can decide at what rate it can go up. At the state level, what they created in the Tenant Protection Act of 2019 was a cap. The reason it's a cap is that it's not based on inflation. And so what we really mean when we say that the rents can only go up by inflation is that we're saying basically your rent's not going up, because inflation is supposed to be describing kind of how that value has gone down with the rising costs, right? So that the reality is, if your landlord started charging you 2,000 at the beginning, that they still can cover their costs because you give them a little bit of an increase, because of the increase in costs. And that's what inflation is supposed to be, is an increase in cost. So saying that you can do 5% above the increase in cost is basically saying that a landlord can make 5% just across the board additional profit every year, plus any increase in costs. So that's a little bit, that may not sound so crazy, but if you think about, if this year, the CPI in most places, it's about 4%, you're saying that a 9% increase. And then next year, it's last year's 9% plus that. So it's 18% in 2 years. And then, in some places it can be up, inflation might be even higher than that. And the cap though is 10%, which is also the amount we say you can do. You can't make the prices above 10%, or you're what's called price gouging if there is some kind of state of emergency. So this kind of shows how, so the blue line basically shows us what the rent is if it's just based on, if all you have are the state protections. And as you see, that gap just gets bigger and bigger and bigger. Communities like Los Angeles, Santa Monica, and Berkeley are the red, yellow, and green, depending on what percentage of CPI. So in Berkeley, for example, you're looking at an increase of 1.5 to 2.2% of CPI, but that really adds up, and that speaks to why things are just getting really, really expensive for people, despite the fact that we did this rent cap at the state level. So another reason why the state protections aren't enough is it excludes a lot of people. So owners of, if you live in a duplex or a triplex as a landlord, then none of those tenants get protected. Tenants who live in condos aren't protected, or single family homes, unless they're owned by corporations, don't have any protection. So the landlord can kick them out for no reason at all, can quadruple the rent. If the property was built less than 15 years ago, they don't have any of these protections. If the owner shares the kitchen and bath, I think that we all would, I think that's pretty reasonable. And dorms, hospitals, and hotels. But and I think that the reason Section 8 units are exempt is because the federal government is the one who determines the rent. But I think the fact that duplexes, triplexes, condos, and single family homes, and any property that's less than 15 years old, all of those tenants have no rent protections or just cause. So really difficult. So what's just cause? So this has come up a lot during the pandemic, because when we talk about the unequal experience for tenants depending on where you live, we've really seen it during the pandemic. So just cause means that there's basically a specific list of reasons that you can evict someone. You can't just evict them for no reason at all, and you certainly can't evict them for just any arbitrary reason. So the state came up with a specific list, but local communities can also come up with lists. And unfortunately, another issue with the state protections is that they're big, massive loopholes. And I'm going to talk about those in a minute. So this is the state just cause ordinance. And frankly, the pieces around the fault part are really not an issue. Very, some of them I think maybe a little bit unnecessary, but in general, pretty similar to most of the other ones. But when it comes to the no fault, huge problems. And two of them are particularly problematic. And just, because we don't have a lot of time, I'm just going to focus in on the substantially remodel. That alone is going to basically, and is basically swallowing up the entire state just cause ordinance. The substantial remodel allows landlords to say, it's going to take me more than 30 days to repair the property. You have to move out. And all I have to give you is essentially a month's rent. And I don't have to let you come back. And I don't have to let you come back at the original rent. This really should be labeled the gentrification eviction. So if anyone thought that just cause was supposed to prevent displacement and prevent gentrification, not prevent, let's make our neighborhood fabulous, but let's just displace the community that has made it fabulous out. And so that is, and we're seeing it across the state where entire buildings of long-term tenants are basically being evicted using this thing. So that really is one of the biggest problems, and is one of the big reasons why you need a local just cause ordinance to fix. And many jurisdictions are doing that right now. So the other big pocket is what has happened during the pandemic. And I'm going to, one of the things I wanted to show, now this, many of the NPR affiliates across the state did research finding out how many tenants got sheriff evictions. Because I think, as folks have shared, it's hard to get the real eviction data, because we simultaneously protected that data, whether people have evictions or not. But what is troubling is that, and so we're talking about where people are being removed by the sheriff. That's only represents a few of, a certain percentage of the evictions, but it does reflect the most vulnerable tenants, because those people are less likely to have gotten legal services. They're most likely to be homeless because of that physical eviction. So you're able to look at this, and what I think is really interesting is that if you see, for example, during the entire pandemic, Richmond only had 50 sheriff evictions. Vallejo had 104. Oakland, which had 33, is significantly bigger than, for example, Antioch had 91. So Antioch is the same size as Richmond, and it had double. Berkeley, or Oakland, only had 33, and it's, 450,000 people. I'm trying to click on Berkeley's, because Berkeley had 0. And one of it has to do with that they have every kind of tenant protection. They have 100%, like every tenant is guaranteed an attorney. We have financial programs for rental assistance. We have strong rent control, strong just cause, and Berkeley has proactive enforcement by the rent board there. San Francisco had 113, which is almost as many as Antioch had. Antioch has no protections. And I think what's important to know is that while there were pandemic protections, they've ended. And that the new protections, as of April, any tenant who lives outside of basically a very few cities, so Alameda County is pretty wholly protected. But 1 in 4 tenants across the state actually have less protections now than they did because they passed the extension, the so-called extension of the eviction moratorium. 1 in 4 tenants have less protections than if they had taken no action at all. And we can, that's less about this. And I think that the most important thing is for people to really realize that we need to start focusing on what are we doing next? right? Because essentially, except for a few parts of the state, the protections are over. Now, big parts still have it. The city of Los Angeles, Berkeley, Oakland, all of Alameda County, Sonoma County is still protected. But we lost a lot, and we can talk more about that, because obviously, while things, I think there's a lot of discussion on where we are in terms of our recovery. Tenants still can't pay, and there are no protections for most people as of April 1st for April's rent. And this is just a recent statistics only for January and February about how half of California renters with low incomes are still struggling to pay their rent. And the rental assistance ended at the end of March. And so for a lot of people, there are no protections or support. And I think this is where I'll pause, and I'm going to head over to my colleague.
Thank
So
you
I'm going to
much.
close out and stop
Okay.
sharing. And Martina is going to.
I think we have a little poll first, Martina. Thank you so much, Leah. One of your poll. I wanted to introduce Martina. Martina Cachuyu Lim has been an advocate for human rights and immigration, housing, and equal access to the law for defendants in death penalty eligible cases for over 15 years. Martina joined the Eviction Defense Collaborative in 2018 as executive director. The Eviction Defense Collaborative is the lead agency for the implementation of San Francisco's tenant right to counsel, overseeing 9 legal service organizations providing full scope legal representation to tenants most at risk for eviction. Thank you so much, Martina. This is the poll going on right now. If everybody can see it, if you have a chance to answer it, please take your time to answer right now. That would be great. And she is going to take it away.
Thank you so much, Laura. Hola, hello everybody. Buenos dias, good morning, good afternoon, good evening. I don't know where you are. This has been, first I want to thank all of the panelists who came before me. Listening to other people talk, I'm reminded over and over and over again of why I'm committed to this work. So I'm taking a look at this poll, and it looks like the majority of people are not sure what the tenant right to counsel movement is. And I hope that by the end of my presentation, you'll know a little bit more about what we're talking about with right to counsel. I'm going to give it another second. Okay. So we've heard about the barriers to justice. We've heard about what the process is like. Leah shared with us a number of policies. Oh, here we go. Let me share the results. The results were that 63% of individuals weren't sure what the tenant right to counsel movement is, and 37% were. So a lot of information to be shared. So what do we do now, right? We've got barriers, we've got policies that perhaps we want to put in place, but we haven't really talked about a change to the system itself. And that's what I want to talk about today with tenant right to counsel. This is about enforcement. This is at the center of what Leah was talking about. You can have all of these protections, but you need enforcement. So I want to walk you through a little bit about the process for a tenant in San Francisco before we had tenant right to counsel. And that's what TRC stands for, y'all. So we've got this tenant here and they don't know what to do. Where are they going to go? So first thing, so they walk over to a number of legal services organizations. But those legal services organizations, they don't help with answers. They don't help immediately. What they do is to say to the person, you got to go over to Eviction Defense Collaborative. So now tenants got to go to another place. And at Eviction Defense Collaborative at the time, we provided them with their answer. And then what would we do? Well, then we would say, go back to the legal services organization. Let's see what, and maybe they can provide you some sort of assistance. Full scope, limited scope, pro per, we don't know, but you know, good luck with these other organizations. And then those other organizations, they might send a person over to a mediation support. So we're talking 1, 2, 3, 4 steps just to try to get some sort of services. Alternatively, the tenant could go to the counseling and social services organizations. And what would they do? They'd send people over to Eviction Defense Collaborative. And again, we would provide any kind of support that we could, but we might be sending people back to the counseling services and maybe to the mediation support. Alternatively, people could go straight to EDC. And ultimately, that is what ended up happening. After years of having this system in place, with EDC providing assistance with answers, 95% of the answers that were being filed in the courthouse were actually processed by Eviction Defense Collaborative. So when the time came for us to think about how do we design a system for tenant right to counsel across the city and county of San Francisco, the first thing was, well, we got to build on what we have. We can't completely rebuild a system. We had about 9 months, I think, to go from 0 to 100 with implementing tenant right to counsel. And so that's what we did. We built on this system. And what we focused on were 2 primary goals. One, we wanted to reduce the amount of steps that a tenant has to take to access services. And we also wanted to increase the access points, taking into consideration that when I say increasing access points, I'm not just talking about brick and mortar. I'm talking about, can you access services by phone? Can you access services online? Does it have to be at the legal services organization? Could it be at another community nonprofit that you're familiar with? That's what has been the forefront of our mind when we're thinking about tenant right to counsel. And I think it's very much the motto, the ethos for nonprofit services providers: meet our clients where they're at. And we can provide the best services for them if we do that. So where are we today? If you see here, the system is very, very similar with the San Francisco tenant right to counsel system. But what's different is that the tenant no longer has to walk between Eviction Defense Collaborative and the other legal services. What happens now is that if someone comes to Eviction Defense Collaborative, we provide an immediate intake to determine what kind of services does this individual need. Do they need help immediately, or do they have time for us to pair them with a full scope representation counsel? Once we do that assessment, we identify the agencies that have availability to take on a full scope representation case. We get the information that the lawyer will need to be able to represent this individual. We work with the agencies to run a conflicts check. And then, and this is all happening in real time, the tenant is given the name, address, and the day and time of an appointment where they can go and meet their full scope rep attorney from the start. I may not look like a lot, but that is a huge, huge difference for tenants when they don't have to go through all of the runaround of trying to find where are they going to get services. So that's where we are today. But you know, the hope was in 2019, we were about 6 months in to implementation of tenant right to counsel, and then COVID. I mean, 2020, and then COVID, right? So yay. The goal when we initially were starting out, or the vision, was for the following. What I and everybody wants to see happen is, let's increase the access points. Let's make it so that if someone goes to a legal services organization and that agency is not able to provide services, let's make it possible for that agency to do the legwork of reaching out to Eviction Defense Collaborative. So Eviction Defense Collaborative can take it upon itself to find another attorney who can provide services to that person. Alternatively, let's say somebody goes to a counseling organization. We want those counseling agencies to be able to provide hot referrals to EDC so that EDC can then take it upon itself and find someone to represent this tenant. And what if a person, you know, if a tenant doesn't need eviction defense services just yet, they're in the pre-eviction stage. Well, we want to be able to share with the counseling agencies the information that the counseling agencies need to be able to provide assistance to that person. Again, this is about minimizing the amount of work that a tenant has to go through just to get services. And lastly, we want to create a connection between all of the counseling and social services organizations that work with tenants and the legal services organizations that work with tenants. We want a direct connection so that, I mean, look at this increase in access points. And even though we're increasing the access points, we're decreasing how much a tenant has to work to get services. So how has San Francisco Tenant Right to Counsel increased the level of services provided? Well, and these numbers that I'm sharing with y'all, they're from the first 6 months of implementation of Tenant Right to Counsel. I looked at the COVID numbers, and given the moratoria, given COVID, it doesn't make sense to look at those numbers. They're not a really good indication of what is going on. And so we're looking at right now the first 6 months of implementation of Tenant Right to Counsel, which again took place in the first 6 months before COVID hit. Pre-Tenant Right to Counsel, about 40% of tenants that were seeking services were getting full scope representation. And I've thrown that phrase around just to make sure that we're all on the same page. What full scope representation means is that from the second the attorney is your attorney, they are your attorney until the case is over. That means if you go to trial, they're your attorney through trial. If you end up coming up with a settlement agreement with the landlord that spans a period of time, 9 months, a year, what have you, that lawyer is your lawyer for the duration of that settlement agreement. You have someone who's going to be with you from start to end, and they are not going to leave your side. And that is huge. Also, before Tenant Right to Counsel, about 18% of people were getting limited scope representation at mandatory settlement conferences. And for those who don't know what that means, essentially it means mandatory settlement conferences are the days in court where everybody has to go and the court wants everybody to kind of come up with an agreement, a settlement agreement. And if you don't, you're going to trial. And what happened, because there was this dearth of attorneys to provide services, what we would do, a lot of the lawyers, is we would show up in court and just be like, we're here, how can we help you today? So you would get a lawyer for the day, but if you couldn't settle something, you were on your own. Sorry, too bad, we just don't have any, we don't have the service, we don't have the capacity to give you more. And then 28% of people would just get a pro per answer, and that's it, that's all they would get. And then there are also a small number of people who would get other kinds of limited scope services throughout the trial. Like maybe they'd come to EDC or an agency and ask questions about discovery requests that a landlord would have sent them. And really a discovery request, y'all, it's basically, hey, here's a bunch of questions that we need you to answer so we understand the facts of the case so that we can present our case. If it's the landlord, it's that we can present our case that you should be evicted. And if it's a tenant, it's that we can present our case as to why I shouldn't be evicted. So that's what discovery is. So now, post Tenant Right to Counsel, you'll see there's a big shift. We've got 67% of tenants who are seeking services are getting full scope representation. And again, that means from start to absolute finish, this tenant is accompanied by an attorney who is an expert in eviction defense. They understand state law, local law, they understand rental ordinances. They are experts in the myriad protections that are or are not in place. And then 6% received limited scope representation at those settlement conferences. And then the percentage of individuals who received just pro per answers, it stayed about the same. Now, that is not an indication of Tenant Right to Counsel not working. That is an indication of Tenant Right to Counsel not being fully funded, because we took all these cases on. We just didn't have enough attorneys to take on that 27%. So what that meant is we still had about a third of the population seeking services not getting full scope representation. So how has tenant right to counsel addressed the barriers to justice that you've heard about today? So I wanted to discuss this in the context of pain points that tenants are navigating. And this is every tenant is navigating this. And that's a baseline. If you are differently abled, if you have a language, if you have a language issue in the sense of you're a monolingual Spanish speaker perhaps, or you are an immigrant who's scared of court because you don't know if you're going to get deported, which is a very real thing. Even individuals who have documentation to be in this country are terrified to go to court to defend their right to continue to stay in their homes, because they're scared if they do that, they're going to get kicked out of the country improperly and without cause. So one of the first pain point that we were addressing, as I mentioned, kind of with our goals, is a fragmented support system of many stakeholders. Laura mentioned that EDC is overseeing 9 agencies, and that's right. We had 9 agencies across San Francisco, all providing services of some sort, but it wasn't coordinated. There wasn't communication among the agencies. And now with tenant right to counsel, we've got hot referrals. We have it so that when someone comes to us and we are making a referral to the other agencies, that agency has all the information they need to hit the ground running in representing this person. And the tenant didn't have to do anything but show up at EDC. On top of that, EDC has real-time information about the capacities of each of the organizations to take on cases. Again, that means that we can just, like that, set you up with an attorney. Again, only if we actually are fully funded with enough attorneys in the system, which we're working towards right now. Another thing that every tenant is facing, which we heard about earlier today, is there's a time pressure. There is a mere number of days for people to respond. Remember that tenant, that slide with all the footprints? So they're running around trying to find all of this help, and they have 5 days to answer. That's a lot of running around and not a lot of time. So one of the things that the tenant right to counsel system is addressing is the instant sharing of case information. Again, this means that it's fast. The process is a faster process. It's more friendly to the tenant, and it's much more effective in getting representation. And the other one that is a pain point that can never, ever be forgotten, and even though I think oftentimes there's an instinct to just put this aside, the emotional trauma of what a tenant is navigating in that moment. It's so much, right? And it's hard to kind of figure out, how am I going to address emotional trauma? You have to. Whenever you're designing this system, whatever system that you are designing, when you're providing services, you have got to be aware of the emotional trauma that individuals are navigating. So what do? We do the work. We are doing the work of finding people for them. We're doing the work for them so they don't have to. So then the next question is, who and how has San Francisco Tenant Right to Counsel helped? Well, 68% of the cases during that first 6 months of Tenant Right to Counsel involved extremely low income households. 18% were low income households, and 9% were moderately low income households. So who are we helping? We're helping the people who cannot afford to pay for help themselves. In addition, 72% of the cases, sorry, I have to move my face over to the other side of the screen to see this, y'all.
Martina, I just wanted to give you a 4-minute warning.
Yep, I'm almost finished. Yep.
For the whole thing. Okay, thanks.
Yep. 72% of cases involved BIPOC households and represent less than 60% of San Francisco's population. 80%, there's an 80% success rate for African-American households, and they actually have the highest rate of success in the entire system. And that does beg a question as to why are so many cases being brought that perhaps shouldn't be brought against African-American tenants. 67% of the households helped remained housed. Of those that moved out, 78% of those moved out with enough time and or money to avoid homelessness. And here's the big one. 90.8% of everyone served avoided homelessness. Now, whenever I talk about tenant right to counsel, one of the big things is, all right, well, what does it cost? Lawyers are expensive. So I thought that the easiest way to explain this is just a side-by-side comparison. The average cost per to represent one household in an eviction is $5,000 versus $61,000 a year that that city and county of San Francisco is spending on tents for safe sleeping villages. So $5,000 to keep somebody from being homeless, $61,000 to give them a tent. It's just, the math is there. It makes more economic sense to be spending on prevention as opposed to, and try to avoid the need for that tent. Laura, I think I came in just under the wire. That was the end for me.
Great way to end. Thank you so much, Martina. We don't really have a whole lot of time for questions. I think there is one question here that's for you, probably Martina or Leah, about the San Francisco Board of Supervisors seeking to increase funding for right to counsel for the upcoming years. Is that happening? And the question about rent increase can be banked for 3 years and added all at once. That's probably a Leah question. So between the two of you.
Yeah, I'm happy to answer the first one. Yes, the city and county of San Francisco has stepped up the investment in tenant right to counsel. However, the investment was based on pre-COVID numbers. So I don't know if they've stepped up enough. I don't think they have. I think they've stepped up a lot, but I still think we've got a ways to go before we're going to be able to ramp up. And there's also just a shortage of attorneys. Even if the city of San Francisco gives us more money, if they don't give us enough money to hire people that incentivizes lawyers to actually come and work and do the work, then it's just not going to be enough.
Yeah, we are really short of a lot of lawyers in San Diego, but I'm going to let Leah speak to the second question.
So in terms of banking for 1482, actually, I'm going to kick it to Gil because you're probably dealing with that more because you've got a community that only is relying on legal aid on tenant, on the Tenant Protection Act. Can you bank? So if you don't raise the rent for 3 years, can you bank under the state law?
No, you're not allowed to. The rent increases are measured retroactively from a 12-month period from when the rent increase is being requested. So it's a look back period. So let's say I'm increasing the rent, for May. From May 1st, we're looking back to see if there have been any other prior rent increases in the last 12 months. And so let's say, 4 months ago, I did a 5% increase. I would be able to do an additional second increase so long as that in the aggregate, the one I did 3 months ago, plus the one I'm doing now is still below the 5% plus CPI or less than 10%, whichever is the threshold, which changes from county to county depending on CPI.
The question that came up about what you could do at local government, I think Martina's last point about the difference in cost is a great point to make, as long as you can keep talking about how much cheaper prevention is. I think that's one of the reasons both Martina and I, we've been working on trying to do more prevention. I wanted to sort of highlight the difference between the San Francisco Eviction Defense Collaborative and ours in San Diego is legal representation. That is the #1 difference. We only have legal aid for low-income tenants and a very few pro bono part-time clinics in San Diego. We don't have the lawyers that both San Francisco area and the Bay Area and Los Angeles have. So it's a huge difference. And so that kind of funding for representation is a huge, very cost effective. That would be my answer.
Yeah,
if I may
real quickly add to that, there was a study in San Francisco that was done that showed that having an attorney represent you increases your likelihood of avoiding homelessness by 70%.
That's fantastic.
Yeah.
We need that.
I also would add that while representation is important, and I frankly feel like if I'm not going to say don't do anything as long as it's in one of those, that kind of chart that I created at the beginning. But if you live in a community where you don't have anything, the only protections you have are the state protections, you still need to pass your own just cause, because if not, you're just going to be defending tenants for evictions that you can't defend. So you need to give lawyers laws to enforce, as well as you need those lawyers. I also want to just put out a pitch to anybody who's in any way connected to the law schools. It is irresponsible for any law school not to have a housing program right now, not to be training lawyers, because you're guaranteed a job. These jobs are also higher paying than, I've ever seen. I don't know if they're living wages, but they are really respectful wages. And we've got great leadership in all of these different wonderful organizations. So if any of you are lawyers out there, are alumni, or in any way committed to the law schools, ask them what they're doing to train these lawyers, because it is the most important thing the law schools could be doing to address the housing crisis, is ensuring that they're coming up, up and coming lawyers know about housing as a profession, and give them the heads up training.
Yeah, no, great point. I think Gil's got a question too. Sorry.
I was going to say, I definitely agree with Leah, and especially, on top of the fact that it's a guaranteed job, if you're interested in litigation, you're going to get so much litigation experience as a young attorney than you would ever get in the private sector. I myself went from law school working at a nonprofit doing housing, and did a couple of jury trials within my first year of being an attorney, which is insane to think about. Yes, they're expedited. Yes, they're unlawful detainers, but it's still a level of experience you wouldn't get to get anywhere else.
Thank you so much. I think that's it for our questions. I just want to point out that I think all of us are in great agreement that the most important thing is that we all have to agree that housing is a human right, and that is our basic. It's got to be our basic standard. I think if anybody's listening to this also agrees with that, you start off with that value, everything else is going to follow. And it's really not about scarcity, it's about values. That's why we don't have enough housing. It's not about scarcity. So I'm just going to finish with that pitch, and I think that's it. Unless anybody else wants to say anything else, we're going to say goodbye. Anybody else? Okay, thank you. I don't know what that was, but thank you, everybody. Bye-bye.